topic we are covering today is drafting complaints and argument. Okay. Now, before I start anything speaking about drafting complaints and arguments, I will just take 4-5 minutes and I'll complete what exactly is 138. Now 138 को हम normal language में if you are a fresher or an intern हम उनको बोलते हैं check bounce case बहुत ये एक मार्केट लैंग्वेज है जिसको हमें समझना चाहिए बिकॉज एंड ऑफ द डे यू आर इन द मार्केट एंड यू बीइंग अ लॉयर्स और व्हाटएवर यू शुड नो व्हाट एग्जैक्टली द टर्म व्हिच इज यूज्ड सो 138 को हम बेसिकली कहते हैं चेक बाउंस केस उसके इंग्रेडिएंट्स मैं बता देता हूं बिकॉज अनलेस एंड अनटिल यू आर अवेयर ऑफ right now since I'm talking about 138 unless and until you are aware of how 138 works drafting becomes difficult okay ड्राफ्टिंग कोई ऐसा चीज नहीं है आपको कोई इतना जल्दी सिखा नहीं सकता है सिखा सकता है प्रोवाइडेड इफ यू वर्क ऑन वॉट एवर यू आर बीन एक्सप्लेन्ड सो ड्राफ्टिंग अच्छा तो तब बनेगा जब आपको उसका इंग्रेडिएंट्स मालूम होगा उसको प्री रिक्विजिट्स मालूम होगा नाउ 138 का सबसे रेलेवेंट जो इंग्रेडिएंट्स होता है वो यही होता है कि चेक 3 महीने के अंदर ही वैलिड होता है लास्ट का 2 डेट आप कभी मत पकड़िए जस्ट फॉर एन एग्जांपल सपोज अगर आपके पास चेक 15 फरवरी का था and if you are trying to encash or present on 16th it will never work out okay because law ऐसा पकड़ता है कि जब आपका चेक बाउंस होना चाहिए you should be within that limitation period of check also चेक 3 महीने के अंदर ही बाउंस होना चाहिए बाउंस का रीजंस इंपॉर्टेंट होता है सिग्नेचर्स डिफर लिटिल बिट ऑफ अंडरस्टैंडिंग बट अगर मान लीजिए आपने कुछ चेंजेस किए अपने हाथों से चेक में एंड देन यू आर प्रेजेंटिंग एंड द रिमार्क इज कमिंग दैट द चेक में कुछ तो इश्यूज हुआ है 138 विल नॉट अट्रैक्ट डायरेक्टली सो जस्ट सी टू इट कि आप इन इंग्रेडिएंट्स को फिक्स करते हो नोटिस हैज टू बी इशूड विद इन 30 days फ्रॉम द बाउंसिंग ऑफ द चेक नोटिस में 15 दिन का टाइम दिया जाता है नाउ देयर आर जजमेंट्स फ्रॉम द केरला हाई कोर्ट सेइंग दैट यू नीड नॉट हैव टू वेट फॉर 15 days इन केस इफ दे रिप्लाई टू यू सेइंग दैट वी डोंट वांट टू मेक द पेमेंट बट फॉर अ सेफ्टी पर्पस आई विल प्रेफर आप 15 दिन के लिए रुक जाइए बिकॉज इंटरप्रिटेशंस कैन गो एनीवेयर सो आपको नोटिस भेजना है विद इन 30 days you have to wait for 15 days the moment that 15 days completes you need to file your case within 30 days सो बेसिकली अगर आप देखोगे तो आपके पास टोटल 45 डेज होता है बट आप 30 दिन के अंदर केस फाइल कर दीजिए इज बेटर टू फाइल एटलीस्ट 5 to 6 days इन हैंड ये आपका मेन इंग्रेडिएंट है नाउ अब मुद्दा आता है कि जब आप 138 केस फाइल करते हो जब हम मार्केट में होते हैं बहुत सारे क्लाइंट्स आपको ऐसे भी आपके पास आएंगे जो आपको ये कहेंगे कि चेक पे अमाउंट क्या फिल करूं सो पूरा जो 138 है ना पूरा क्रक्स ऑफ 138 इज अ लीगल डेब्ट Now, the moment if I'm saying legal debt, it means drafting, okay? Because what is debt, what is legal debt, is the utmost importance to know if you are practicing in 138, even if you are not practicing in 138, but in other civil matters like summary suit, commercial suit, NCLT matters, you should know what is legal debt. Pura ka pura 138. The biggest defense if the accused has is 138 is a legal debt. अब आपको legal debt होता क्या है कैसे होता है that will take another session but in short your transaction has to be very clear. assume कीजिए आपका invoice में amount दिख रहा है 5 लाख और आपने चेक डाल दिया 7 लाख का right that will not be taken as a legal debt because इनवॉइस 5 लाख है तो आपका चेक का 7 लाख अमाउंट आया कैसे इनवॉइस 5 लाख का है चेक में आपने 4.5 लाख डाला है या 5 लाख डाला है दैट विल बी टेकन एज अ लीगल डेट सो एनीथिंग व्हिच यू आर ट्राइंग टू फिल इन योर चेक इफ यू हैव अ ब्लैंक चेक देन प्लीज फॉर गॉड्स सेक जस्ट कीप अ पॉज प्रिपेयर योर स्ट्रेटेजी एंड देन ओनली यू डू दिस ओके Now, by I always prefer that you should be aware of your pre-litigation strategy and post-litigation strategy. अगर आपको pre पता है, and if you are able to understand कि मेरा pre क्या होगा, and you are in a very definite, you are in a better situation to understand कि post क्या होगा. If you are very well aware of these two methods, your drafting will be almost what the court calls for. It means it will be non-debatable. Ingredients क्या होता है drafting का? Well, I have seen in many matters. I don't know for what reasons. Complaint को हम seriously लेते ही नहीं है. I think we have started relying more on Google nowadays. Chat PGT, AI code. ये हम कैसे भी एक फॉर्मेट ले लें और उस फॉर्मेट में हम अपने इंग्रेडिएंट्स पुट कर दें और केस फाइल कर दें. ओके, लेट मी टेल यू, ऐसा नहीं होना चाहिए बिकॉज कंप्लेंट ड्राफ्ट करना this is what let me tell you. Drafting of complaint can never be replaced by artificial intelligence. Never. Anytime. Maybe at least I'm taking this 40 years. Even if the technology goes to a very big extent, drafting has to be done manually only. And there are various reasons. आप कितना भी अच्छा सॉफ्टवेयर बना लो, drafting will always be the part of manual work to be done by an expert. Because it's a very good saying, अगर आपका ड्राफ्टिंग परफेक्ट है ना, आपका आर्ग्यूमेंट ऑलमोस्ट 70% कट आउट हो जाता है. Then you don't have to think about arguing the matter for your 100% matter. You just have to argue on that 30%, assuming if there is any defense being raised by them, and even if it has a logical. But if your drafting is good, trust me, most of the matter will get settled. 138 में अगर कोई मैटर 4-5 साल चल रहा है, एक्सेप्ट टेक्निकल इश्यूज, अगर आप टेक्निकल नहीं है और अगर डिबेट हो रहा है आपके पॉइंट पे, इट मींस समवेयर वी आर लैकिंग इन ड्राफ्टिंग. नाउ ये ड्राफ्टिंग ऑफ कंप्लेंट आता कैसा है? जब आप नोटिस इशू करते हो. ओके, आई जस्ट हैव वन क्वेरी. आई वाज जस्ट थिंकिंग, मान लीजिए मैं अक्यूज्ड हूं और किसी ने मेरे पर 138 का नोटिस भेजा. सो माय वन क्वेश्चन इज वेदर द अक्यूज शैल रिप्लाई टू 138 और नॉट. If you are a complaint lawyer, you will say आप रिप्लाई नहीं करोगे तो भी you fall under 138, आप रिप्लाई करोगे तो भी. But just think from an accused side whether he should reply to 138 का notice or not. Plain, without getting into the strategy wise, you should not. As an accused lawyer, just try to see that you don't reply to that letter. Because in case if you feel you have any defense, don't open it right now. डायरेक्टली कोर्ट में ओपन करने का. आप पहले ओपन कर दोगे, देन यू आर गिविंग द कंप्लेनेंट अ चांस टू कम विद अ न्यू स्ट्रेटेजी. राइट नाउ if you are really thinking about ethics and everything, let me tell you, see, ethics is good, no doubt, but when the matter comes to you as a lawyer, ethics says that you have to be very clear to your client what you will do, and this is where the strategy works, right? So it's nothing about ethical or unethical. Okay, because someone has asked me earlier, कि सर ये ethical होता है क्या, रिप्लाई नहीं देना देना. रिप्लाई देना नहीं देना is a part of your legal strategy. So whatever you are doing, just think, थोड़ा pause दे दो अपने mind को, put a legal strategy, and then reply नहीं reply, that's your call. Now how you will draft a complaint? The biggest, आप जब cost title डालते हो, I am not getting into that part, but मुझे एक चीज आप लोग से बताना है. Suppose if I'm Lalit, I have there is an opposite party who is an accused, and his company name is Fireflies Legal Private Limited. ठीक है, वो प्राइवेट लिमिटेड है. नाउ चेक मुझे इशू किया प्राइवेट लिमिटेड ने. ओके, मैंने नोटिस कैसे भेजा? नाउ आई हैव सीन दिस. आप नोटिस में ऐसे लिखते हो, मान लीजिए फायरफ्लाइज लीगल प्राइवेट लिमिटेड का ओनर टॉम, मिस्टर टॉम है. ओके, आप ऐसे लिखते हो, टू विदाउट प्रेजुडिस टू टॉम, दैट्स इट. नीचे आप एड्रेस डाल देते हो, या तो आप ऊपर लिखते हो टॉम डायरेक्टर ऑफ फायरफ्लाइज लीगल प्राइवेट लिमिटेड, एड्रेस डालते हो और भेज देते हो. डू यू रियली थिंक ये नोटिस वैलिड है? इट इज नॉट वैलिड, बिकॉज यू आर नॉट मेकिंग द कंपनी एज अ पार्टी. So this is where drafting comes into picture. This is where your pre-litigation, your post-litigation strategy comes into picture. आप डिफरेंस समझ गए? भूपेश राठौड़ का एक जजमेंट पास हुआ था. आई विल प्रीफर कि आप लोग उस जजमेंट को पढ़ो, बिकॉज दैट जजमेंट वाज वेरी क्लियर कि आप एक छोटा सा मिस्टेक करते हो तो हाउ द कंप्लेंट कैन बी डिसमिस्ड एंड शुड नॉट बी डिसमिस्ड. आई एम जस्ट रिपीटिंग द नेम ऑफ द जजमेंट इज भूपेश राठौड़, पास बाय आई थिंक दिस इज सुप्रीम कोर्ट जजमेंट. तो जब भी ऑपोजिट पार्टी अगर कोई प्राइवेट लिमिटेड है, पब्लिक ट्रस्ट है, पार्टनरशिप है, प्रोप्राइटर है, पुट द नेम ऑफ द फर्म फर्स्ट एंड देन नेम ऑफ द सेकंड, थर्ड, फोर्थ डायरेक्टर्स और पार्टनर्स और प्रोप्राइटरशिप और ट्रस्टी. आई एम प्रीटी मच श्योर दैट मोस्ट ऑफ द टाइम वी फेस डिफिकल्टी अंडरस्टैंडिंग कि साइन किसका है. Okay, let me tell you, it happens, आपको नहीं पता होगा कि इसमें साइन किसका है. In that case, हो सके तो प्राइवेट लिमिटेड, एलएलपी, पब्लिक लिमिटेड, ओपीसी प्राइवेट लिमिटेड, ट्रस्ट. ट्रस्ट का एक अलग चैरिटी कमीशन होता है, बट ट्रस्ट या नॉन प्रोड्यूसर कंपनी, आप आरओसी में जाके सर्च कर लीजिए, ट्राई टू रीड देयर एओए एंड एमओए, put the name of the directors, let them come in the court and file an application that I am not a part of 138. You don't make their life easy कि चलो ये नहीं आएगा, मैं इसका नाम नहीं डाल रहा हूँ, because you never know साइन किसने किया है. If even if you know कि साइन किसका है, if possible, put the name, but there has to be a relevant specific allegations to be made in the complaint. So I hope that I have clarified this part. Now, सबसे first paragraph of the complaint. Suppose if the complainant is a private limited or a partnership firm or LLP or OPC. So यहाँ पे दो एंटिटी आते हैं, प्राइवेट लिमिटेड, प्रोप्राइटरशिप, और एक HUF मान के चलिए. और other than this is B. Now I have seen this, that when you file a case, first para में nobody intends to mention who is filing the case, on whose behalf, and how he has got the power to file the case. Okay, so I'm taking an example that I am a private limited as a complainant, and now I'm filing a case against another private limited or somewhere. My first para, drafting of complaint का पहला para has to be this. No other para should replace this para. क्या होगा? The complaint hereby states that the complainant hereby authorize Mr. Lalit Jain, comma, whatever his designation is, I am taking as a director of ABCD Private Limited, authorized wide board resolution dated dash, as he is aware of the business transaction and the matter against the accused, and accordingly, the copy of the board resolution is hereby marked and annexed at Exhibit A. First para आपका यही होना चाहिए, यही. If a proprietorship or a partnership or an HUF is filing a case, go for specific power of attorney. If not, then board resolution. अगर board resolution है, आपको लगता है उसमें power of attorney का statement है, go for the term. I am using the term specific power of attorney. Don't use the word general power of attorney, because there are judgments which says that the person who is filing a case at an evidence stage has to be aware of the matter. So the term specific comes into the relevant part. आपको बहुत common लग रहा है. I am telling you, the power of attorney भी कैसे, I have seen power of attorney कैसे आता है. आप ऑनलाइन चले जाते हो और कॉपी पेस्ट कर लेते हो और फाइल कर देते हो. In one of my cross, when I asked the accused कि आपने एक power of attorney फाइल किया है, he said yes. आपको तो कंपनी ने पूरा भार दे दिया. बोला हाँ. आप कितने मैटर्स हैंडल करते हो? उन्होंने कहा सब मैटर्स हैंडल करता हूँ. बोला ये मैटर भी हैंडल करते हो? उन्होंने हाँ कर दिया. And when I said कि is there any specific intention by the complainant to authorize you, उसने ना कर दिया. So this is where I got an open window कि हाँ, this बंदा is not at all aware of this transaction. वो डिफेंस आप मत दीजिए. Use the word specific if you are using a power of attorney. Board resolution है, your board resolution. For God's sake, don't again. The reason I am using this word, don't copy. See, information आपको online लेना है, लीजिए. Nobody is stopping you. Use your brain. That's it. Board resolution में there has to be a specific statement why you are authorizing whom and what will he or she be doing in this matter. Again, I am repeating, the board resolution be like this. Resolved that he is hereby authorized by the company to file an application, deposit evidence, file an affidavit and verify it, to file written submissions, complaint, applications, get everything जो भी आपका requirement है. Avoid the word settlement unless and until he himself is the owner of that complainant firm. Settlement का power उसको मत दीजिए. If you are a company, मत दीजिए. वो अलग बात है, it depends on your faith and trust, but मत दीजिए, because settlement जब आप term डाल देते हो, it becomes a little bit debate. अगर in case if that person whatever happens to him. So drafting of board resolution has to be very specific, power of attorney. So again, I am coming to my first para of my drafting. The first para of the drafting has to be authorization. Please note it, authorization. Other than this, आप कुछ मत डालिए. Second para has to be the follow-up or first. The second para has to be I mean to say the person name. I say that I am totally aware of this matter. I am aware of the transaction done with the accused. I am in total understanding what has happened in this matter, and accordingly, the complainant has authorized me to file this complaint. So para number 1 and para number 2 of the drafting of the complaint has to be this. कुछ नहीं आना चाहिए ये दोनों को छोड़ के. Don't try to get into other point. ये दो चीज आप clear कर दो. So what this will do is, this will stop the accused in stating that the person who has filed a complaint or an evidence is not aware of this matter, is not a part of the complainant firm. He is totally new to this, stranger to the contract, ABCD. So the complaint ka first 2 para has to be this. Now comes what has to be para number 3. Now what I normally do is, मेरा ये 2 point हो गया. Whenever you write any letter, or the best way to explain how to draft a complaint is, in higher courts you need to file a synopsis. Okay, हम synopsis का purpose क्या होता है is that date wise you need to tell exactly क्या हुआ है. So that will help the higher courts in time consuming कि भाई मुझे dates बता दो क्या हुआ है, and you tell me which is the date which is more an issue for you. This is where your drafting comes into picture कि whenever you draft आपका फ्लो बराबर आना चाहिए. आपने पैरा नंबर 1 और पैरा नंबर 2 में आपने अपने बारे में बता दिया, राइट. पैरा नंबर 3 हैज टू बी फॉर द अक्यूज्ड. हु इज द अक्यूज्ड? अक्यूज्ड नंबर 1 कौन है, 2 कौन है, 3 कौन है, 4 कौन है. Now I am pausing myself and I am repeating one statement. I have seen in the drafting of the complaint that the public use the word that the complainant hereby states that he know the accused and his business. मत कीजिए. Be very specific. आप वर्ड यूज कीजिए that he is aware who is accused number 1, 2, 3, 4, whatever. So पूरे कंप्लेंट में आप accused को accused नहीं लिखेंगे, आप लिखेंगे accused number 1, 2, 3, 4. Right? One thing I am telling you, except an individual is an accused, everywhere there will be 2 accused, and if there is an individual, 1 accused. अगर वो एक भी accused है तो भी, just to avoid any interpretation, use the term accused number 1. That's it. And if you want, you define as an accused. That's okay. But use the term 1, 2, or 3. Be very specific. So your third para has to be about the accused. And then fourth para, you should tell about the entity of the accused, right? A company hai, private limited hai. So now you have completed the 4 paras. So basically, what you have done is you have informed the court and the accused that the person who is coming to the court is totally aware against the accused of the matter, what is in the matter, what to be filed in this matter. And most of the times, in fact, you have taken 40% of the defense of the accused out. But now your 5th para, 6th para, 7th para, whatever is your transaction, this is where your experience comes into picture. Neither I will say you put everything in detail, neither I will say you try to hide out. Don't do that. Be very specific. Now, just giving an example, suppose आपके पास एक check है, वो 3 बार आपने bounce किया, 1, 2, 3. You have an option. या तो आप तीनों के बारे में बताओ और एक ही बताओ जो लास्ट हुआ है. Suppose if this is one of the query you are asking me, I will prefer who is the accused, what was the intention behind filing this case, and accordingly I will use 3 का या तो 1 का. Now most of the time मैं 3 का डाल देता हूँ, but it depends कि accused कौन है, क्या exchange of communication हुआ था, whether that suits my matter or not. So basically after 4th para, your business communication has to come into picture. आपने क्या business किया, ये पैसा कैसे आया, क्यों नहीं आया. The reason I am telling you कि drafting difficult नहीं है, but drafting requires your mindset to be very concentrate. See, this is where you reading the judgments, you are being aware of what is going in the market. You are totally aware कि कौन से judge ने आज क्या judgment pass किया and what that particular judgment speaks about. So I will prefer. Everybody is busy in this world. Okay, everybody is busy except whoever it is. बट आप दिन का हो सके तो 1-1.5 घंटा और 1 घंटा ट्राई टू रीड जजमेंट्स, जो भी आपका स्पेसिफिक इंटरेस्ट है, जस्ट रीड जजमेंट्स, बी अवेयर ऑफ द जजमेंट्स। और आजकल जजमेंट्स तो व्हाट्सएप पे आपको फ्लो में आता है। आई एम नॉट सेइंग यू रीड ऑल द जजमेंट्स, बट जो आपको कैची लगता है आप ले लो, आप पढ़ लो उसको। द रीजन आई एम टेलिंग यू, बिकॉज एक जजमेंट पढ़ने से आपको ये समझ में आ जाएगा कि मुझे ड्राफ्टिंग में लिखना क्या है। ओके कितने लोगों को ये पता है कि मनी लेंडर्स का एक्सेप्शंस क्या है, कंडीशन प्रेसिडेंट क्या है? I was surprised when in one of the matter happened, and I'm surprised कि most of them they were new, उनको पता ही नहीं था कि एक मनी लेंडर का कंडीशन प्रेसिडेंट भी होता है। Nobody knew it. There are conditions precedent. ये आपको कैसे पता चलेगा जब तक आप रिसर्च नहीं करोगे। So when I say pre-litigation strategy, it means as a lawyer, if any matter comes to me, before I issue any notice, I will do my research कि क्या ट्रांजेक्शन था, क्यों हुआ, क्या हो सकता था। The moment I do my research, I am totally in a position or in my mindset, okay, ये मैटर है, लीगल ये बोलता है, so accordingly नोटिस में ये बनाऊंगा, right? Your notice content cannot be different to what you are drafting in complaint. नोटिस में इतना रामायण देने की जरूरत नहीं है, you need to be very specific, चेक आया, चेक दिया, खत्म हुआ। But your notice content and your complaint cannot have a two conflict unless and until there is a small typo error, which definitely you have to put in your complaint, and that is admissible by the court for issuing the summons and other also. So आपने जब अपना 4 पैराग्राफ दे दिया, this is where you need to share your business transactions. आपने business transactions बराबर से दे दिया, so अपनी अपनी इच्छा है आप उसको कितने पैरा में करोगे, बट आई प्रीफर डोंट ट्राई टू पुट, अगर ये एक पेज है, आई हैव सीन वन पैरा इतना, आई मीन टू से 25 लाइन का एक पैरा कोई नहीं पढ़ने वाला। सी लेट्स रिस्पेक्ट द कोर्ट, बिकॉज व्हेन दे आर सिटिंग देयर दे हैव मेनी मैटर्स, डोंट एक्सपेक्ट देम टू रीड ईच लाइन। हो सके तो मेक योर पैरास बी वेरी स्पेसिफिक, आई मीन सी द इंटेंशन ऑफ द पैरा हैज टू बी कि ये पैरा में कवर क्या हो रहा है। If you are able to define your para, I am telling you, you are actually saving the time of the court. And I am telling you, if your drafting comes in that way, that will only help your matter, because even the court appreciates that this is where I have to give more my thoughts and everything, because it is not that every para has a relevance. कुछ पैराज आर मोर लाइक अ फॉर्मल पार्ट, जैसे आप लास्ट में लिख देते हो अलाउ मी द राइट टू फाइल अनदर डॉक्यूमेंट्स, फेयर इनफ, आपको लिखना भी चाहिए, दैट्स अ पावर, बट दैट डजंट मीन दैट यू कैन फाइल एडिशनल एविडेंस एवरी टाइम टेकिंग दैट क्लॉज एज अ रेफरेंस, राइट? सो अब थोड़ा पैरा को डिफाइन कीजिए। मान लीजिए आपने 5th 6th 7th में आपने पैराज लिखा, सो आई एम जस्ट टेलिंग यू कि ऐसा कौन सा रेलेवेंट पॉइंट्स वर्ड्स है जो होना चाहिए। दिस इज व्हाट आई फील is the debt is acknowledged and undisputed debt. This has to be the part of your complaint. I'm just using the word that the debt is undisputed and acknowledgement of debt is there. Number one, the debt has been approved or acknowledged by the accused and hence it is a legal debt as per the provisions of Negotiable Instruments Act. Why you are using this term? Because you are actually, when you go by the flow, when you draft any complaint, the moment you reach to that particular point, you are trying to tell the court that if you read from ABCD, I have proven that this debt is a legal debt. And one of the ingredients of 138 is a legal debt. So when the opposite party or the accused, they go for the cross of the complainant, you should not give them a window that this is not a legal debt. You prove it, this is a legal debt. भाई मैंने सभी प्रूफ कर दिया मेरे इसमें। Now I'm just taking a pause. I will tell you one of the cross query which the opposite party ask you. आपने मान लीजिए ये अपने कंप्लेंट में डाल दिया जो सेम एविडेंस होगा, most of them they do that, I'll prefer don't do that, I'll come later. उसका पहला क्वेश्चन क्या आता है कि आपने जो भी अपने एविडेंस में लिखा है पैरा वाइज, जो आपने इस पैरा में लिखा है वो सही नहीं है, खत्म। आई मीन टू से आप बोलोगे नहीं बराबर है तो बराबर ही होने वाला है। But suppose if the accused lawyer is able to ask such a question जहां पे आप you might get little bit confused कि आंसर क्या देना है, but at least you have put in your evidence because it happens. It is not like this कि आपके से एक error हो गया तो आपका पूरा matter खराब होता है. No, even the law says that cross में अगर majority of the answers were in such a manner that it proves the case of the complainant. आप कोई भी एक छोटा चीज लेके you cannot debate against the complainant. There has to be a probable defense. Now the probable defense has got its meaning in the various Supreme Court judgments. Okay. अभी आपने business के बारे में बता दिया. Then you say that the check was released towards the discharge of the legal liability. Because as I told you, 138 is all about कि check क्यों मिला? Discharge of legal liability. This is one of the ingredient. So हो सके तो use these words. बाद में definitely as a procedure आप क्या बोलोगे कि मैंने ये check ये तारीख को present किया, bounce ये तारीख को हुआ, ये मेरा bank details है, ये तारीख को हुआ, and then there has to be one para about if notice भेजा क्या उसके पहले आपका बात हुआ. Suppose if before you issue a demand notice there is an email exchange or the discussions have happened before notice, you should put that if at all, if it is before notice, right? Notice भेजना mandatory है. Let me say again, notice under section 138 is mandatory. It is a condition precedent for you to file a case. Civil matters में ऐसा नहीं होता है. Like summary suit, not mandatory. Recovery suit, not mandatory. MSME, it is not mandatory. Arbitration, it is mandatory. You have to issue a section 21 notice. So section 21 of Arbitration Act, you have to tell me it is equivalent to section 138 of NI Act. Both the notices are mandatory to be issued in case you want to invoke the respective provisions to go before the court or the arbitration. बराबर है. आपने उनको जब नोटिस भेज दिया, you have to tell कि मैंने नोटिस भेजा था. Now, I prefer that way. जब आप नोटिस भेजते हो, then you say कि the notice was issued via postal receipt bearing number. Please put the number of the postal receipt. Don't make mistakes. बराबर है. आपने डाल दिया, रिटर्न आया नहीं आया लिख दो. In case if there's any error in the postal receipt, prefer a line statement saying that the postal receipts are at exhibit dash, okay, which proves that the notice was issued. That's it. Everything has to be marked an exhibit. आप वो कर दीजिए. In case कभी ऊपर नीचे error हुआ, the postal receipt gives more value to, होता है typo error something it makes, but just ensure that you don't make any error. आपने notice cover कर दिया. Then limitations point has to come. Limitation क्या होता है? As I told you, check was presented within 3 months. The moment check was bounced, I issued a notice within 30 days. The moment I issued a notice, they have received on dash date, and within 15 days, they were supposed to make the payment. My limitation, my cause of action started from the 16th day. So I was bound to file within 30 days. I have filed on this date. ये आपका limitations हो गया, cause of action आ गया. And then you put that, आपका prayer क्या है, और उसके पहले you just put that, normal statement saying that I'm producing the documents whatever I have, and then I will produce whatever it. And then there's a prayer clause. A prayer clause में I have seen many of them copy paste. Simple. 2 साल का सजा दे दो, double the check amount दे दो, वो छोड़ो. आप समझिए आपको चाहिए क्या, डालिए. See, I'm not saying everything, जो भी मैं बोल रहा हूँ ये होना चाहिए नहीं होना चाहिए, but at least prayer has to be very important. आपका prayer ही नहीं है, आप क्या claim करोगे? In any law of recourse, whether it is 138, summary suit, NCLT, arbitration, consumer, RERA, insurance, ombudsman, shipping arbitration, Bombay stock, if your prayer is not there, even if you have a matter, nothing will happen to you. It will be dismissed. So, हो सके तो prayer को ज़्यादा time दो. Think what you want. आपने prayer डाल दिया. Now, the moment you put the prayer, आपका complaint as such पूरा हो गया, but it is still not complete. Verification. Now verification I have seen लोग कैसे लिखते हैं. I'll just जितना मुझे याद है I'll just repeat. I Lalit agent dash deciding hereby declare and state that I am aware of the facts and I verify the facts. नाम वाम sign कर दिया. Do you really think it has any meaning in law? No. Do you really think that this verification has any stand in law? No. Do you think by this verification you are giving an accused a chance to put you in cross? Yes. Why? Verification. You should read CPC and CRPC manual. Verification एक art है. It is a defined art. What it says, you need to specify which para you as an individual is aware, which para as a lawyer legal से मालूम पड़ा, which para you are assuming has to be true, and which para is a prior clause. There is a judgment by the Bombay High Court in Jasmine matter. Based on that verification, the complainant failed to prove the case that he is aware of the matter in person. Just imagine. Just because the verification clause was not there, was not proper, was not as per the criminal manual, the complainant lost the case in High Court. So that is the importance of verification. So don't take anything lightly when you draft 138 ka complaint. It is applicable to even civil matters also. But क्या होता है civil matters में, see 138 has become a more of a technical matter. एक defense पे भी, एक defense अगर accused ने दे दिया which has a probable defense, it will be dismissed. So why to give that probable defense by your end? Let them do that. Let them do that. उनको थोड़ा मेहनत करने दो. आप उनको एकदम स्पून फीडिंग करोगे तो कैसे चलेगा, है ना? वेरिफिकेशन हो गया, आपका ड्राफ्टिंग ऑफ कंप्लेंट अब जाके 60% हो गया. 60% ही हुआ. Why? Where is the 40%? Affidavit in support of the complaint. Affidavit has to be as per affidavit format under CPC and criminal manual. Please read it. Verification shall be very strictly as per criminal manual. Don't be very casual when you do that. The moment you complete verification, आपका पूरा का एक complaint draft हो गया. And I'm telling you, once you do this, you don't give any point of small window to the accused to argue. पूरे complaint में you need to specify the allegations on each accused. So now I'm coming to that para number 5 से लेकर नीचे तक जो business transactions था. If there are more than one accused, specify the role of each accused. I'm just taking an example that you are filing a case against a company. You are not aware of whether accused number 2 ने sign किया, 3 ने sign किया, 4 ने sign किया. And there's a Supreme Court judgment that you should specify each and every allegations. And again, there's a Supreme Court judgment saying that the person who is not a part of the company shall not be made as a director. But recently there was a judgment that how the complainant will know which director has a role to play. So when you file a case against them, let them come and debate that I am not the part of it. बराबर है ना? So interpretations होते रहेगा. But you don't fall to the prey that ये law है तो यही precedent है. Judgments as a precedent will change anytime. If today I am speaking before you at 6 o'clock saying कि ये judgment precedent है, maybe after half an hour you will find a new judgment कि वो precedent change हो. So rather than giving our matter, आपने उसको हवे में टांग दिया, is better to specify, because one thing is very clear. If your drafting and if your complaint is very specific, is very core to what you want, none of the precedent, none of the judgment will take away the complaint from you. बहुत simple है, बहुत simple है. Because at the end of the, at the end, what lawmakers want or what the court wants is that when you filed a case, you came with a very clean thought process. Everything is documented. Everything is in line. Everything has a sync with the events. You are not hiding anything. Hiding or not is a part of legal strategy. I'm leaving it to each and every respective, persons. But बनाना कैसा है? आप इस तरह से बनाइए so that none of the precedents, whether in the past or the future may come, will affect your matter. आपका complaint पूरा हो गया. Then definitely सबका अपना अपना practice होता है. जैसे कि यहाँ पर practice है कि you need to give list of witness, memo, docket, and then exhibits. इन सब चीजों में एक चीज let me tell you. Suppose आपका 4 invoice है जिसका payment नहीं आया हुआ है, okay? और वो 4 इनवॉइस को आपने ई-वे बिल के थ्रू आपने एग्जिबिट डाल दिया और एक लेजर डाल दिया. नाउअडेज क्या हो गया, सबके क्वेश्चंस आने लगा है कि ये चारों इनवॉइस फेक है. हाँ, हमको मिला ही नहीं. अच्छा, ई-वे बिल है, उसका कोई वैल्यू नहीं है. ओके, वेल यू हैव अ डिफेंस, यू रीड जीएसटी एक्ट, इट इज वेरी क्लियर. बट assuming this question might come up, and suppose if you have a business done with him for more than 4 invoice, then I will prefer कि आप 6 invoice डालो, बैंक स्टेटमेंट डालो and tell them कि ये invoice है, 6 में से 3 का पेमेंट बैंक स्टेटमेंट में दिख रहा है, लेजर है, इससे ज्यादा क्या बचा? ई-वे बिल है, जीएसटी लॉसेस, ई-वे बिल इज मैंडेटरी बियॉन्ड 50,000 and less than 1 किलोमीटर जो भी है, आई एम डन विथ माय पार्ट. बैंक स्टेटमेंट जब आप दोगे, get it signed, each page duly stamped, rubber stamped, signed by the bank manager. बैंक मैनेजर है, किसी और से मत लेना, नहीं तो अगेन उसका अथॉरिटी लगता है. जब आप एग्जिबिट्स देते हो, just see to it that you make a very perfect case. ऐसा कोई कंप्लेंट नहीं होता जो परफेक्ट होता है, am I right? But at least the perfect has to be from your side in regard to your matter in terms of everything. You should know कि मैंने क्या रखा, मैंने क्या नहीं रखा. कुछ सरप्राइजेस नहीं आना चाहिए आगे जाके. हाँ, ऐसे केसेस होते हैं जहां पे आपके क्लाइंट्स ने आपको पूरा इन्फॉर्मेशन नहीं दिया हुआ, बट देन दिस इज वेयर द लॉयर कम्स इनटू पिक्चर. आई ऑलवेज फील अ गुड लॉयर इज अ लॉयर हु नोज कि ये इवेंट में कुछ तो मिसिंग है जो क्लाइंट नहीं बता रहा है. यू आर द क्लाइंट. अगर वो फिर भी नहीं बताता है, यू डोंट टेक दैट कि मैं इसको छोड़ देता हूँ, जो होगा सो होगा. नहीं, जस्ट टेक दैट कि ये हो सकता है, ये आएगा, एंड देन अकॉर्डिंगली यू ड्राफ्ट योर कंप्लेंट सो दैट कल को वो आता है, you are already covered in your complaint. You as a lawyer don't make any assumption. I'm telling you, assumptions and presumptions has no role in drafting. Don't do that. आप argument कर रहे हो, you use the word, I am leaving it to you, but drafting में don't make any assumptions and presumptions. Only think what will happen and what you want to cover right now in a way so that आपका purpose भी solve हो गया. क्लाइंट ने आपको नहीं बताया, दैट्स फेयर इनफ, दे शुड से, बट यू नो क्लाइंट्स लोग नहीं बताते ज्यादातर कुछ चीजें, एंड यू कैनॉट फोर्स देम, राइट? बट यू शुड एज अ लॉयर एंश्योर दैट यू आर हैविंग अ प्योर सेफ्टी इन अ मैनर कि उनका काम भी हो गया, मेरा काम भी हो गया, एंड ऑपोजिट पार्टी दे आर इन अ सिचुएशन जहां पे मैं बताऊंगा तो वो भी अटकेंगे, नहीं बताएंगे तो ऐसी अटक ही रहे. यू नीड टू प्ले योर क्रिकेट वेरी वेल. सो दिस इज वेयर योर ड्राफ्टिंग कंप्लीट्स. कंप्लेंट फाइल हो गया, समन्स इशू हो गया. नाउ व्हाट? एविडेंस कम्स इनटू पिक्चर. नाउ आई हैव सीन, दिस इज व्हाट आई हैव सीन, दैट जैसा कंप्लेंट है कॉपी पेस्ट मार दिया एविडेंस. आई एम नॉट सेइंग कि ये गलत है, बट लेट मी यूज दिस वर्ड, बट दिस इज नॉट अ गुड वे टू ड्राफ्ट एनी एविडेंस. ओके, भले ही आपका कंप्लेंट सेम है एविडेंस जैसे, एंड डेफिनेटली यू शुड हैव इट बिकॉज आपका कंप्लेंट और एविडेंस चेंज नहीं होना चाहिए, बट देन अगेन इट डिपेंड्स ऑन योर स्ट्रेटेजी. एविडेंस में इट इज आई, कंप्लेंट में इज द कंप्लेंट. एविडेंस में द ओनली पर्सन हु इज अवेयर ऑफ द मैटर, business transaction can do that. There is a settled law that any person can file a complaint and get the summons issued, but the evidence can be filed only by those persons who are exactly in personal knowledge of the matter. So if you are a complainant, ensure this. Evidence को ध्यान से बनाइए. Pattern has to be same like a complaint, but just see to it that everywhere it is me and I. It is not the. Okay? मुझे पता है, मैंने ये किया है, ये ट्रांजेक्शन हुआ, मैंने चेक डाला, ऐसे हुआ, ऐसे होना चाहिए था. So एक बार आप जब एविडेंस बनाते हो, having a good drafted evidence and the complaint will reduce the cross query to be asked by the accused lawyer. Okay, I'm just sharing one example जो recently हुआ था. So a case was filed by the sole proprietorship. ठीक है? So the proprietorship was owned by the father and the son filed the case. Evidence ये थी, and we filed a specific power attorney. They made an application saying that a son cannot file because he is not aware of the matter. I'm pretty much sure answer has to be rejection. But now what is happening is that they are trying to prove he is not aware of the matter. You know why I'm happy? Because I know even if they do that, every there is in place in the complaint and the drafting that ये होने वाला है. I mean to say, I know उनके कितने भी क्वेश्चंस आएंगे, but my evidence is drafted in a manner कि वो 50 क्वेश्चन भी पूछेगा, मान लीजिए उसे 10 गलत भी दिया, it will never take my matter away from it, because everything has come into picture कि as an individual मुझे क्या करना चाहिए. That's it. There's a limitation I have done my part within that boundaries. Evidence फाइल करो, आपका क्रॉस आएगा, क्रॉस आने के बाद डेफिनेटली जैसे क्रॉस होगा, जैसे आई हैव सीन कि लोग ना ज्यादा I don't know for what reason. You should always, जैसे आपका एविडेंस होता है, आपका क्रॉस आने वाला होगा, इफ पॉसिबल आप अपने क्रॉस क्वेरीज को मेंटेन रखो कि एक्यूज क्या पूछ सकता है. यू प्रिपेयर योर क्लाइंट ओके इन अ मैनर, और आप उनको थोड़ा कंफर्टेबल फील कराओ. बिकॉज आई हैव सीन मेनी ऑफ टाइम दैट द लॉयर से टू द क्लाइंट कि नहीं आप चिल्लाओ मत, कुछ मत करो, ये कोर्ट है वोट है. अरे कोर्ट उनके लिए बना है. वी आर अ फैसिलिटेटेड टू देम, मेक देम कंफर्टेबल इन कोर्ट, टेल देम डोंट लुक टू द आईज टू द लॉयर, स्पीक टू द जज. जज को आप आंसर दो. इफ यू हैव एनी क्वेरीज आस्क जज. ऐसा कोई क्वेश्चन आता है जिसमें आपको लगता है यस और नो बोल के फायदा नहीं है, बट द ऑपोजिट पार्टी बोलता है यस और नो बोलो, आंसर हैज टू बी लाइक दिस, नो. हाउएवर आई वांट टू से दिस, नो कोर्ट कैन टेल यू कि आप ये मत बोलो, बिकॉज दे हैव टू रिकॉर्ड एवरीथिंग व्हाट यू एज अ विटनेस यू डू. बराबर है, आपका क्रॉस सब हो गया. नाउ आई एम कवरिंग द पार्ट ऑफ रिटन आर्ग्यूमेंट्स और आर्ग्यूमेंट. सी आर्ग्यूमेंट एक तरह से आप आपका अगर ड्राफ्टिंग परफेक्ट है, आई एम टेलिंग यू, यू इफ सपोज आपका आर्ग्यूमेंट या ड्राफ्टिंग बराबर नहीं होता, आपको लग रहा है मैटर में बहुत कुछ ऊपर नीचे हुआ है, एंड यू हैव टू पुट लॉट ऑफ टाइम एंड एफर्ट्स टू आर्ग्यू द मैटर. Having a proper drafting, having a pre and post strategy will reduce your headache for arguing the matter, because by the time you reach this stage, either the matter will be settled, or even everyone, you might be aware कि matter में सब हो चुका है, exhibits हो चुका है, and I am pretty much sure that the matter will come to an end in my favor. Overconfidence is bad, right? No overconfidence, but you should be confident about your matter. Confidence रहेगा, then only you can tell your client कि ये करना है, नहीं करना है. There is a matter, which I know it is pending for the last more than 8 years, वो अभी भी चल ही रहा है और चलेगा, because of a mistake made by ABC. Then arguments. अब argument कैसे करो? If possible, put down your written arguments in a manner not more than 1 page or not more than 2 page. It has to be very specific. रिटर्न आर्ग्यूमेंट्स आप करोगे कैसे? आई हैव सीन पब्लिक जो कंप्लेंट में डालता है वही रिटर्न आर्ग्यूमेंट में डालता है, वही जज को दे देता है. अरे रिटर्न आर्ग्यूमेंट का पर्पस ही खत्म हो गया फिर. फॉर गॉड सेक, रिटर्न आर्ग्यूमेंट हैज टू बी लाइक एक स्टोरी राइटिंग होता है, हम कहानी लेकर लिखते थे ना, प्रेसी स्टोरी. अगर आपका कंप्लेंट 10 पेज का है तो रिटर्न आर्ग्यूमेंट शुड नॉट बी मोर देन 1.5 पेज. लिखना कैसा है? फर्स्ट पॉइंट, इंग्रेडिएंट्स ऑफ चेक. चेक प्रेजेंटेड, refer para 28 of complaint, para this of evidence, no cross taken, admissible by accused, matter खत्म, finished. खत्म हो गया, 3 लाइन में आपने प्रूफ कर दिया, चेक खत्म हो गया. नोटिस was sent, no was reply, accepted, no cross was taken. बाद में आप लिखोगे the check was bounced, जो भी था, cross was taken but not sufficient enough to prove probable defense. खत्म हो गया. Then the question was asked about the specific knowledge. Para this states very clear. Para this specific knowledge admissible by accused, matter khatam. Just imagine if you are putting your para in 3 lines and then you are putting dash admissible by accused, bracket no probable defense raised by accused. Just imagine your 1 page is enough for a judge to read and pass the order in your favor. If you are an accused, you can do the same part. Just imagine. If you are referring any judgments, for God's sake, आप जजमेंट का लिस्ट ऑफ डॉक्यूमेंट्स बनाइए, फर्स्ट पेज पे इंडेक्स बनाइए, इफ पॉसिबल टैग कीजिए रिलेवेंट पॉइंट्स, और फर्स्ट पेज पर आप डालिए इस जजमेंट में ये पेज नंबर पे ये लिखा हुआ है, एंड मेक इट अ पार्ट ऑफ योर रिटन आर्ग्यूमेंट. पुट अ पैरा इन योर रिटन आर्ग्यूमेंट दैट आई एम एनक्लोजिंग द लिस्ट ऑफ जजमेंट्स एज अंडर. खत्म. I am telling you, if this is the manner, if you are able to put up in your matter, there is no way, I mean to say, see, the way you argue, I understand it depends how argue kaise karna chahiye, but this is where the whole matter completes you to get a good matter in your favor or a bad matter in your favor, right? As a lawyer, we never get any good matter or bad matter. We always get a matter jo thoda upar niche hoga, but this is where your experience, your strategy will come into picture to make that matter in your favor. बस कंप्लेंट पूरा हो गया. सो इन शॉर्ट, if I am completing, a good drafting will take away from the accused most of the defense. A bad drafting, even if you have a good case, you will expose yourself in a manner that you will lose the matter. Now, I have seen that public, they go to classes, सर्टिफिकेट ले लेते हैं, they put it saying that I have done my drafting का course, but trust me, unless and until you don't read the judgments, okay, and you don't understand कि क्या method था, what was the perception behind this judgment, unless and until you are not aware of the facts of the matter, you cannot do any draft. Drafting only comes यहाँ से आता है, और ये इज लाइक सीपीयू, यू नो, एक तरह से ये आपका माइंड सीपीयू है, आप उसमें स्टोर नहीं करोगे इफ यू डोंट रीड, इफ यू डोंट अलाउ योर माइंड टू यू नो सोचने में, यू विल नॉट बी एबल टू पुट एनी एफर्ट्स ऑन ड्राफ्टिंग. सो इफ पॉसिबल ना, आप हर दिन एक जजमेंट पढ़िए, कीवर्ड्स को मार्क कीजिए, इफ पॉसिबल आजकल बहुत इजी हो गया है, जजमेंट पढ़ के कीवर्ड का एक शीट बना लीजिए. This keyword will help you in drafting your notice and complaint and evidence and cross. End of the day, keywords ही काम आने वाला है. This is the way you should complete your drafting and everything. I am just closing my today's session saying that I have heard saying that drafting difficult है by most of the interns and the freshers, और वो करते ही नहीं है. ऐसा कुछ नहीं है. ड्राफ्टिंग विल कम ओवर अ पीरियड ऑफ टाइम. एक साल में तो कोई नहीं सीखने वाला, एक साल में भी सीख जाओगे आप, बट स्टार्ट रीडिंग, अंडरस्टैंडिंग, पुटिंग कीवर्ड्स एंड देन एनालाइजिंग द मैटर. ये चार चीज आप करोगे, आई एम प्रीटी मच श्योर, either it is 3 months or 5 months or 6 months, your drafting will come to a stage जहाँ पे it will take care of your matter. Okay, don't go by the logic perfect. There is nothing perfect. इतना perfect होता तो आपको convictions का order आता ही नहीं था.
Sir, by keywords, what do you mean, sir?
See, क्या होता है? I'll tell you. If there was a judgment passed by Kerala High Court saying that it is not mandatory that you put everything in detail कि notice check क्यों issue हुआ था, right? अब होता क्या है कि जब आप वो judgment पढ़ते हो, आपको keywords मिलेगा, जैसे कि notice में क्या-क्या होना चाहिए. What demand has to come in a notice, okay? Section 138 का provision होना चाहिए. Then who is sending the notice, वो होना चाहिए. So if I am saying keywords, you know, keywords can be differentiated from me and you. But एक judgment से जब आप keywords निकालते हो, you understand कि ये keywords से ही ये judgment का rationale बढ़ा है, और ये keywords ही मेरे केस में काम आएगा. So suppose if किसी ने demand word use ही नहीं किया 138 में, so I will say कि this notice doesn't meet the criteria of 138 because there was no demand made. It was just a notice to be sent in a notice. However, वो अलग बात है that principles of natural justice or interpretation में anything can be changed here and there, but keywords means which will help you in understanding how to draft anything. I mean, either it is notice or letter or everything. End of the day, keywords, don't take keywords of Google वाला keywords. Keywords बोले तो हम legal part. You know what exactly the judgment speaks about. What are the new terminology which you feel which help me in my matter to draft a complaint or an evidence or a written argument. Knowing the keywords will make you a good writing argument.
A check given by a guarantor default हो जाता है तो whether it can be under 138.
हाँ हो सकता है, but then it depends कि आपका उसके साथ agreement किया हुआ है, because most of the time ना हम guarantor word use कर लेते हैं, but I have seen कि there is no agreement and you cannot even prove that is a guarantor. So if your agreement is in place, if there is a proof that he issued a check as a guarantor, you can do that. And definitely there has to be a provision that, you know, he acted as a guarantor for the borrower for whatever the money he has taken. क्योंकि इंडियन कॉन्ट्रैक्ट एक्ट में हम उसको श्योरिटी बोलते हैं. So yes, you can.
ये मनी लेंडर का कंडीशन प्रेसिडेंट भी होता है, इसमें समझा नहीं है, उसका केस लॉस आपने बताया.
सी मनी लैंडिंग में क्या होता है, सेक्शन 25 से लेके 45 तक देयर आर कंडीशन प्रेसिडेंट्स कि मनी लैंडिंग का क्या रेस्ट्रिक्शंस है और लिमिटेशंस है, यू नो, वेदर व्हेन दे कैन फाइल द केस और नॉट, व्हाट दे हैव टू डू एंड एवरीथिंग. मनी लैंडिंग जो हम लाइसेंस लेके बैठ जाते हैं, आई विल प्रीफर कि ये सेक्शन 25 से लेके 45 अगर आप पढ़ोगे ना, उसमें क्लियरली दिया हुआ है व्हाट आर द थिंग्स हैज टू बी डन बाय द मनी लेंडर इफ दे वांट टू फाइल अ केस and what scenario they should not file a case. So there are compliances being given.
Thank you, sir. Sir, case laws आपने बताया था जैस्मिन कुछ.
अच्छा, जैस्मिन का, okay. See, बॉम्बे हाई कोर्ट का एक जजमेंट है जैस्मिन का. The judge name was, but वो जजमेंट आप पढ़िए. This is the best judgment you will find. Understand what is the importance of verification and how to draft a verification and evidence. अगर आप गूगल में डालेंगे ना जैस्मिन बॉम्बे हाई कोर्ट, आपको आ जाएगा.
A check is issued by a drawer which on presentation gets returned unpaid. And then when it is informed to the drawer, he makes a partial payment of that check. And thereafter, he does not make any payment. The check is still valid and it can be presentation. The 3 months period, limitation period is still there, and the check can be again tendered for payment. So what are the precautions or anything which should be taken or anything? Because now here the legal debt or the liability has been reduced, whereas you got a check for the entire value.
I know ये होता है, and this is a very smart move. So see, there is a law which says that as on the date of the check being presented, the liability was there, the debt was there. You can take this as a point of your argument and file a case. Now, I'm taking a scenario कि आपने check डाला, okay, 1 लाख रुपए का, और उसने आपको whatever 50,000 pay कर दिया. Now, I will prefer, don't get the check bounced again, file a case for 1 lakh. On the point is that when I got the check bounced, आजकल check bounce होता है तो messages आ जाता है, right? और लोग क्या करते हैं, आधा पेमेंट करते हैं ये बोल के कि मैंने पेमेंट कर दिया. So you don't get into any exchange of communication with them. आपको पता है, मुझे भी मालूम है, आपको समझ में आ गया पेमेंट आया नहीं आया, but don't reply to them. Okay, and you file a case. The filing में जब आप केस करते हो, your point has to be as on the date of me presenting the check, the total liability was this amount. ठीक है, डेफिनेटली आप नोटिस इशू करोगे, तो जब आप नोटिस इशू करोगे वो आपको रिप्लाई करेगा कि मैंने आपको पेमेंट कर दिया. तब आप उनको क्लियर बोलना कि जब मैंने ये चेक डाला था, वी वर नेवर इन्फॉर्म्ड ऑफ एनी पेमेंट बीइंग रिसीव्ड, ये करके, सो वी टोटली डिनाई दैट एनी पेमेंट हैज बीन मेड. सो व्हाट विल हैपन इज दैट एटलीस्ट जब आप केस फाइल करोगे, व्हेन यू गो टू द कोर्ट, यू कैन टेक अ स्टैंड दैट व्हेन आई फाइल्ड अ केस, उसमें मैंने लिखा था that when I presented the check was legally debt, but without me informing him, without he telling me or getting into the part, he made some payment which I am not aware of. So let it go to the trial. But होता क्या है कि कोई point में, this is where your drafting comes into picture, you should not admit everything. Let him come to the cross and say that. वहां पे वो अटक जाएगा, because वहां पे point क्या आएगा when the cross is there, that when the check was issued, you knew it कि 1 लाख देना है. So when the check was bounced, you made the payment without informing them. So that shows the guilty mind. So 138 works on guilty mind. Intention has to be there. But you need to be little bit strategies कि हम इसको कैसे use करें, because कोई ये भी बोलता है कि on the date of filing the case कितना debt था. So if you don't reply to them, and if there is no exchange of communication, at least you can take a stand कि I was not aware of it.
So to add to this, actually, after the first bounce of the check, the 30 days period wherein we are supposed to issue the notice have been elapsed.
Then तो फिर you
So
don't.
that is the reason why you have to re-tender the check and get it bounced. In such scenario.
See, in such scenario, then you lose filing the case, because what happens, suppose if you issue a check and you don't issue a notice, okay, and he makes the payment within that particular time. So there is an assumption being made that you had a talk with him, and then, since he not made the payment, you are again filing, presenting the check. So if I am an accused advocate, I will take the plea that we had a talk, I made a part payment. Now again he presented the check, so there is no legal debt. And this happens, I am telling you, this happens. So you need to be little bit vigilant, because see, as I told you, 138 is a very technical matter. And law has given a very clear point that if the accused is able to raise a probable defense, then, so ये probable मैंने यही होता है कि if he is able to at least give an information कि ये जो claim है is not an exact claim, and there is something I have done, probable defense में आ गया, so the matter will be dismissed.
Sir, my query is that checks were issued, okay, then it's bounced. 138 was filed by the complainant.
Okay.
Then after 2 years, there was settlement. MOU was signed and fresh checks were issued.
Okay.
And again, fresh check is if bounced. So we can move with the current 138 matters, or we can send a fresh notice or fresh proceedings?
No, don't file a fresh proceeding, because for one transaction you cannot have two matters. You can in any case, when you file any MOU before the court, and if you don't withdraw the matter, it is before the court only as a consent term. So suppose if that check is bounced and if it is not working, you can issue a notice. Okay, but you continue with that old matter. Don't try to file a new matter, because what will happen is that, first of all, if the proceedings is in process, you cannot file second proceeding for the same matter, because already the proceeding is before the court. And in any case, then you have to pay double the court fee. In any case, that will be dismissed.
Yes.
So पैसा भी बचेगा, और उसी में in fact that works in your favor, because एक बार MOU sign हो गया, so debt तो admitted हो गया है.
Yeah.
हाँ, बस क्या, फिर तो you can even claim double the check amount. But there's a judgment by the, I think, Rajasthan High Court and Delhi, that if the MOU is signed and the check is bounced, you are in a position to claim the double the check amount and sentence.
Okay.
Jammu and Kashmir, state of Jammu and Kashmir. There's the latest judgment, hardly 8 months back. I think that was the best judgment you will find. Why the adequate compensation shall be given to the complainant. Best judgment of Jammu Kashmir. Yasmin 138, Jammu and Kashmir High Court. Yasmin.
Mostly the complainant files for the application under 143 for 20% of the check amount.
Yes.
And if already the accused has paid the 70% of the check amount, then the court can give order for 20%.
No, if the 70% is already paid before filing, then the case cannot be filed. And if it is paid after filing, then they have to pay 20%, because the law says when the check was presented, there was a legal debt, and the law says that 20% of the check amount. It doesn't say pending amount. If you're an accused and if you have a good defense, okay, pay 20%, go to the evidence and get the matter in your favor. Don't open your defense in 143 stage.
There is a case where a party gave a loan to somebody on interest. So that interest was continuing for some years, TDS was being deducted. Now, suddenly there was the relations between the parties got going. One party, the recipient, expecting foul play by the other person, deposited a certain amount, part payment, in his account. And then the other person deposited the checks after that and filed a 138 case. In this case, our plea is that your due amount is not as per your check amount. While the samne wala party, this thing is that it is to be adjusted towards interest.
So you are appearing for accused, right?
Accused.
So I'm assuming that the complainant person is not here. So now I can give you some defense.
Yes.
If he's here, then you need to fight it out. See, first of all, be very clear कि ये loan क्यों दिया था और interest उसने कितना लिया. Because reasonable interest के ऊपर अगर आप interest लेते हो, you are not allowed to do that in any manner. Because money lenders cannot take more than 2% per month, right?
Yeah.
First, your defense has to be कि ये loan क्यों लिया. Second, आपने कितना पेमेंट किया वो देखो. Because क्या होता है, there is a rule of दंपत्ति, if you can understand. Interest cannot go beyond principal amount.
Right.
Go with this two logic. It has to be in your favor.
If the check is issued by the CFO or on behalf of the company, but after bouncing of the check, the same CEO has changed the job and some new person has came in his place. So the action is still maintainable under 138.
Why not? He has signed the check. So when the transaction was done, he was in the daily affairs of the business, section 141. He has to be. In fact, the new CFO will not be come into picture because he was never the part of that business transaction. So he will take the claim of 141 that I was never the part of this business.
So who will be the accused in this case?
If it is a company, then the person who has signed and the other directors, but not this new CFO. But in case if you are not aware who is new and old, put everyone and let the accused come in the court and fight it out that I am not. थोड़ा accused को मेहनत करने दो. And if you are an accused, then I am sorry for this reply.